The television courtroom had never witnessed such a moment of pure, unfiltered arrogance meeting its absolute destruction. I have sat behind many benches, but today, the arrogance in that room would be answered with something far heavier than words. Brenda Marshall, a 380-pound woman in her early 50s who had spent 6 years terrorizing small business owners with fraudulent lawsuits, sat in the defendant's chair with the kind of smug superiority that can only be cultivated by someone who has never faced real consequences for anything in her life. Her perfectly manicured finger pointed directly at me as the words that would cost her $75,000 and years of freedom spilled from her lips with breathtaking audacity. "Maybe you should calm your hormones, Judge," she said. The room went quiet in a way my gavel has rarely ever heard. For a television moment, this was viral in the making, but I do not do theater. I do the law. I do evidence. And when she attacked me with a sexist, ageist taunt, she did more than insult the person in the robe. She revealed the contempt that animated her entire scheme. Brenda did not just lose a single case. She did not merely get embarrassed in front of millions of viewers. What happened next was the collapse of an enterprise. What I did in the 30 seconds that followed was not a merciless spectacle. It was the judicial and investigative unmasking of a criminal operation that had extracted $412,000 from vulnerable immigrant business owners, closing shops and ruining livelihoods. The legal work done in that courtroom set off federal criminal investigations across multiple states. It exposed a playbook of organized extortion disguised as civil rights advocacy. And it began the process of restitution for victims who had been bankrupted by orchestrated shame campaigns. I will tell you what I told her in my voice, because the facts had weight and the law demanded clarity. "You have a playbook," I said, "and I have read it. The pattern is unmistakable. Target small businesses owned by immigrants who cannot afford to fight. Make impossible accommodation demands that would cost thousands. Record the refusal with hidden cameras. File a lawsuit claiming discrimination under federal and state statutes. Launch a coordinated negative review and media campaign. And then offer to settle for an amount, $8,000 to $15,000. That is just below the cost of defending a case to trial. That arithmetic is cruelty turned into a business model." Brenda had perfected the mechanics. A failed stint in law school, 8 years as a paralegal, and a gut-level understanding of how expensive litigation is for those without resources taught her the arithmetic of fear. She found doctors who would sign off on dubious medical claims for a fee. She recruited accomplices to serve as scripted witnesses. She created digital templates for defamatory reviews. She marketed a coaching product that taught others how to repeat the scheme. She even had counsel who drafted complaints with the language calibrated to maximize a business owner's panic. The operation was precise, profitable, and industrial. But she forgot a basic truth. The law leaves a trail when criminal intent exists. Patterns leave fingerprints, and one of her alleged victims, Miss Linda Cho, refused to be anonymous. Linda, a 39-year-old immigrant who saved and worked for 15 years to open a small wellness spa, refused the settlement. Instead, she did the painstaking thing most victims cannot afford to do. She researched, she found the other victims, she hired a private investigator, and she collected evidence that contradicted every theatrical claim Brenda had made. When Linda's investigators sent unedited footage of Brenda walking easily through a store, carrying groceries, pushing a cart, and playing with her dog, the narrative of incapacity collapsed. When documentary records showed coordinated review campaigns, complaint cascades, and when bank records suggested an organized flow of settlement proceeds, the civil case required a much wider response. I do not enjoy spectacle. I require proof. But proof came, and it built like a dam over her lies. In court, I asked direct questions because soft questions allow predators to read the room and adjust. When I asked how many lawsuits she had filed, the answer could not be ambiguous: 47. When I displayed the scrolling timeline on the screen, the business names, dates, amounts, the architecture of a scheme became visible not to a single proprietor, but to the public. When she rose from her mobility scooter, contradicting sworn medical affidavits presented in dozens of filings, that single movement was a critical piece of documentary evidence. I explained to the courtroom the gravamen of the situation. The ADA and state anti-discrimination laws protect real people from real harms. They are not a licensing scheme for extortion. When a plaintiff uses disability claims as a means to extract money through manufactured indignation and coordinated reputational attacks, they have crossed from civil grievance into organized criminality. Civil law provides remedies for injury. Criminal law addresses schemes aimed at systematic profit through fraud. The law understands this. So do I. I told the courtroom what she had done in precise terms. She identified victims by vulnerability, immigrant ownership, tight margins, reputational exposure, and then applied coordinated pressure, hidden camera performances, carefully edited footage, and a wave of fake reviews that looked organic were the tools of her trade. She built a network, paid witnesses, corrupt medical sign-offs, a lawyer who drafted fearsome complaints, and even a digital marketplace teaching others how to repeat the play. I have seen a lot of bad behavior on my bench, but this was organized, repeatable, and monetized. When I referred the matter to federal authorities, I did so because the pattern suggested interstate wire fraud, tax violations, and organized extortion. I do not make referrals lightly. Federal resources are not infinite. Prosecutorial decisions are solemn. But when the documentary trail shows repetitive filings, financial flows, fabricated documentation, and an online instruction operation, that is the kind of case federal agents should and did pursue. Subpoenas followed. Bank records were traced. The pieces of the puzzle fit together. What moved me personally was not the theatrical insult, though I will not tolerate that in my courtroom. It was the human cost. Small business owners had been bankrupted. Families had spent life savings fighting a manufactured fight. Employees lost jobs. Marriages frayed. All so one person could monetize grievance. The law was designed to protect the vulnerable. She weaponized it against them. That I will not allow. The public response was swift because the television moment crystallized something many viewers felt. Outrage at gaming of protections meant for the disadvantaged. But the legal result was not instantaneous. It required careful assembly of admissible evidence, unedited surveillance footage with verified chain of custody, independent medical evaluations by physicians with no conflict, bank transfers and settlement records, archival captures of online coaching materials, and review campaigns. When the evidentiary discipline is rigorous, public exposure becomes an accelerator for accountability, not a substitute for it. At the conclusion of the hearing, I rendered a judgment. I awarded Ms. Cho reimbursement of legal fees in the amount of $22,000 and punitive damages of $50,000 for malicious prosecution and fraud. The lawsuit was dismissed with prejudice. She may not refile the same claim. More important, I transmitted the exhibits to the appropriate criminal investigators and requested expedited review because the documentary record supported charges beyond the civil claim. The bench does not act as prosecutor, but the bench can assemble a record that prosecutors can follow. There is a lesson here about the architecture of vulnerability. Predators prey on isolation. Scams that rely on victims who do not compare notes, who fear exposure, or who cannot afford extended defense metastasize quickly. That is why community, documentation, and legal aid matter. Linda could fight because she found others and persisted. Most cannot. The systemic response must include better early warning detection, docket analytics to flag repeat plaintiffs, cross-jurisdictional alerts, and community legal clinics empowered to help proprietors document and respond quickly. Those are practical reforms, not slogans. Let me be practical about remedies and reforms, because feelings don't fix systemic holes. Policy does. Judges have inherent authority to impose pre-filing restrictions on vexatious litigants. When someone files serial meritless claims, courts can require them to obtain leave before initiating new suits. That gatekeeping is simple and effective. It prevents endless repetition and gives clerks a chance to flag patterns early. Second, sanctions are not merely punitive. They are deterrents. Courts should impose monetary penalties, fee shifts, and, where appropriate, require bond or security before further filings to ensure predatory claimants cannot empty a community through coercive litigation. Technology has a role, too. Platform operators who host reviews and complaint forums must build rapid detection tools for coordinated manipulation. When dozens of negative reviews appear from newly created accounts, or when review language is template-like, platforms should preserve metadata, suspend suspect accounts, and cooperate with verified legal processes. That preserves consumer trust and shrinks the playbook predators rely on. I want to address another corner of this crime: the market for false medical assessments. We saw in this case doctors who signed reports for a fee. That is professional misconduct and potential criminal facilitation. Licensing boards must act swiftly when credible evidence of fabricated medical opinions surfaces. When physicians provide false documentation for financial extraction, they compromise public confidence and the integrity of disability protections. Regulatory bodies must treat that as a severe breach, and boards should coordinate with investigatory authorities. Now, a word to small business owners watching: preventability is costly, but not impossible. Maintain clear, time-stamped records of appointments, back up unedited footage off-site, keep correspondence organized, and cultivate a legal contact for quick consultation. Build community ties so that when a complaint emerges, other proprietors can be alerted and compare notes. Insurance helps, but more important is rapid documentation and outreach. Isolation is an exploitable vulnerability. To my colleagues on the bench, vigilance is necessary. Clerks should be trained to identify red flags. Repeat plaintiffs, identical complaint text, coordinated review spikes. When sufficient indicators appear, judges can consolidate cases, freeze settlement proceeds pending review, and notify law enforcement. Procedural moves like these preserve access to justice while denying predators the anonymity and momentum they rely upon. Let's talk about the human consequence one last time. The economic harm to Ms. Cho was immediate. Lost revenue, canceled contracts, clients who no longer trusted her business. The emotional toll was worse. Panic attacks, sleepless nights, shame she did not deserve. Monetary remedies cannot fully repair that damage, but they are necessary. The restitution orders in Brenda's case sought both to punish and to rebuild, to mark the wrong and to return resources to the injured. What of the attorney who profited from this racket? Counsel who facilitates systematic extraction, face bar discipline, contempt proceedings, and potential criminal exposure if they knowingly aided a fraud. The bar must enforce ethical standards vigorously. Lawyers are gatekeepers of the legal process, and when they abdicate that role for a fee, they corrupt the system. I am clear about that to every young lawyer who watches. Ethics is not optional. I have been asked more than once why a television judge would take on this kind of public action. The answer is simple. Exposure is sometimes part of accountability. Television confers no special power, but it provides transparency at scale. When evidence is displayed clearly and responsibly, victims find each other, witnesses come forward, and law enforcement receives leads it might otherwise never see. That does not mean every media moment should become a trial. It means we can use public scrutiny responsibly when the record justifies it. To the public, do not let cynicism drown courage. Systems improve when people use them honestly. When they are weaponized, reform follows. I have seen both sides of the ledger in my courtroom. Today, the ledger balanced toward restoration. The law will continue to be blunt where necessary and precise where possible. That is how public trust in our institutions is rebuilt, one documented case at a time. To Brenda Marshall, the courtroom is not a stage where you rehearse victimhood for profit. It is a place of law, and the law, when properly applied, strips illusions away. You thought you could weaponize compassion and anonymity for monetary gain. The record shows otherwise, and the sentence and restitution reflect the legal and human damage you caused. To Linda Cho and to the other victims, your courage is a public good. You stood up not just for yourself, but for others who could not. Your willingness to document, to reach out, and to persist made possible a repair that would have been impossible in isolation. That civic bravery restored faith in the law in a way 3 motions could not. One administrative addition I insisted upon: when courts receive patterns of serial filings, clerks should compile a redacted summary of the pattern and distribute it to neighboring jurisdictions and to relevant regulatory bodies. Predators often scatter filings across counties to hide patterns. Cross-jurisdictional communication accelerates detection and assists prosecutors. It is a simple administrative fix with outsized effect. We must convert outrage into institutional change. The next time a pattern emerges, we should be ready because communities, courts, platforms, and regulators will act in concert. That is how we protect the vulnerable and restore faith in justice. Justice requires vigilance and collective action, always. Amen.
Brenda thought the courtroom was a game until the evidence exposed her entire fraud operation in front of everyone. Respect to Judge Judy for standing firm, and to Linda Cho for having the courage to fight back against someone who destroyed innocent small businesses for profit. Real justice finally caught up with her.